Welcome to JSS Matriculation School, Talavadi Social Class. Today, I go to explain you lesson number 3, State Government of Civics. The Constitution of India arises from the federal government having separate system of administration for the union and the states. There are 28 states and 9 union territories and the national capital territory known as Delhi in India. The constitution contains provisions for the governance of both the union and the states. It lays down a uniform structure for the state government in part 6 of the constitution from the article 152 to 237, which is applicable to all the states. The structure of the state government as formed in the center consists of 3 branches. They are the executive, the legislature, and the judiciary. Now we are going to learn about the first one, the executive. In that executive, now we are going to learn about the first point is the governor. The governor is the constitutional head of the state executive. The administration of the state is carried on it's the name of the governor. You know already. Generally, there is a separate governor in each state, but if the situation wants to show the same person may be appointed as the governor of 2 or more states. Article 154 vests the executive power of the state in the governor also. Next, appointment of the governors. The governor of a state shall be appointed by the president. His usual term of the office is 5 years, but he holds office during the pleasure of the president. Generally, the governor does not belong to the state where he is appointed. The governor, he can also be transferred from the one state to another by the president. Next point is, he can also resign anytime by addressing his resignation to the president. The legislature of the state or the high court has no role in the removal of a governor. A person may be appointed as a governor for any number of terms. 2 conventions have been set up in the matter of appointment a person as governor of the state. He should not be a resident of the state concerned, and the state government concerned he consulted and its views are sought regarding to the proposed choice. According to Article 158 bar 3a, where the same person is appointed as governor of 2 or more states, the emoluments of allowances payable to the governor shall be allocated among the states in such proportions as the president may be order determined. Now we are going to learn about qualifications of the governor. Article 157 and Article 158 of the Constitution of India specify eligibility requirements for the post of governor. They are as follows. He should be a citizen of India. The next is, he must have completed 35 years of age. The next point is, he should not be a member of parliament or any state legislature. If he is a member of any of legislature, he automatically vacates its seats on assuming the office. The next is, he should not hold any other profitable occupations. These are the qualifications of the governor. And next, powers and functions of the governor. The governor is the head of the state executive and he has enormous power. In the exercise of function and powers, the governor expect in certain cases is to be guided by the aid and advice of the Council of Ministers headed by the Chief Minister under Article 166. Now we are going to learn about the functions of the governor now, powers and functions. The first power is executive powers. He appoints the leader of the majority party, those who are winning the elections of the state, in the state legislative assembly as the chief minister of the state. The next point of the executive power is he appoints other members of the council of ministers on the recommendation of the chief minister. The next power is he appoints the chairman and members of the state public service commissions. And the next is he appoints the state election commissioner and determines its conditions of the service and tenure of the office. The next point is he acts as the chancellor of universities in the state. He also appoints the vice chancellor of universities in the state also. The next is he directly rules a state where there is the impositions of the president rule in the state also. The next power of the president is legislative powers. The governor is an integral part of the state legislature, but he is not a member in the either houses of the legislature. In this capacity, he enjoys the following legislative powers and functions. In that first legislative power is he has the right to summon or provoke the state legislature and dissolve the state legislative assembly. The next legislative power of governor is he can address the state legislature at the commencement of the first session after each general election and the first session of each year. The next is he can send message to the houses of the state legislature relating to the bill pending in the legislature. The next is he can appoint any member of the legislative assembly to preside over its proceedings when the office of both the speaker and the deputy speaker fall vacant. The next power is he can nominate one member to the state legislative assembly from the Anglo-Indian community. The next one is he nominates 1/6 of the members of the state legislative council from the amongst the person having special knowledge or practical experience in legislature, science, arts, cooperative movement and social services. The next power, legislative power of the governor is he decides on the question of disqualification of members of the state legislature in consultation with the election commission. The next is every bill passed by the state legislature will become law only after his signature. But when the bill is sent to the governor after it's passed by the legislature, he has the option to give his assent to the bill or withhold his assent to the bill or return the bill for the reconsideration of the legislature. He has to reserve any bill passed by the state legislature which enters the position of the state high court for the consideration of the president. The next one is He can promulgate ordinance when the state legislature is not in session under Article 230. But these ordinances must be approved by the legislature within 6 months. He can also withdraw an ordinance at any time. The next point is last point of legislative power. He has to lay the annual reports of the State Finance Commission, the State Public Service Commission, and the Comptroller of Auditor General relating to the accounts of the state before the state legislature. Now, the next power of the president is third powers, financial powers. The Constitution confirms on the governor the duty to get prepared and introduce the state legislature, the annual budget, and also the supplementary budgets if necessary. He caused the annual financial statement, means budget, of the state to be presented in the legislative assembly. He presents through the Minister of Finance of the state the supplementary budget of the state to the legislative assembly if there be such a need. Money bill can be introduced in the legislative assembly only with his superior recommendation. No demand for any grant can be made except on his recommendations. He can make advances out of the state contingency fund to meet any unforeseen expenditures. The last financial power of the president is he constitutes a finance commission after every 5 years to review the financial positions of the panchayats and the municipalities. The next power of the president is judicial powers. He appoints the attorney general of the state. He appoints judges to the subordinate courts in the states also. He makes appointment, postings, and promotions of the district judges in consultation with the state high courts. The next judicial power is the chief justice of the high court in the state is appointed by the president in the consultation with him. Next is last one. He can pardon, commute or reprieve punishment or recept of appeals for mercy except death sentences. The next power of the president, that is the judicial power, is discretionary powers of the president. The governor can reserve a bill for the consideration of the president. Discretionary powers of the governor is he recommends for the impositions of the president rule in the state also. The next is he seeks information from the chief minister relating to the administrative and legislative matters of the state. The next is he can call the leader of any party to form ministry in the state when there is no clear-cut majority to any party in the legislative assembly after the general elections. The next last discretionary power is he can dismiss the council of ministers when it was unable to prove the confidence of the legislative assembly, and he can dissolve the legislative assembly if the council of ministers has lost its majority also. Next, we are going to learn about the last power of the president is emergency powers. if the governor is satisfied that the government of the state is not carried on the accordance with the provisions of the constitutions. He may, under Article 356, recommended to the president to impose president rule in that state. As soon as the president rule in the imposed, the administration of the state is carried on by the governor as the representative of the president. The next is privileges of the governor. Article 361 bar 1 provides the for following privileges for the governor. The governor of the state is not be answerable to any court for the exercise and performance of the powers and duties of his office, or for any act done or purporting to be done by him in the exercise and performance of those powers and duties. The next is, no criminal proceedings whatever shall be instituted or constituted against the governor of the state in any court during his term of office. Next is, no process for the arrest or imprisonment of the governor of the state shall issue from any court during his term of office. The last privileges of the governor point is, no civil proceedings in which relief is claimed against the governor of the state. This is the explanation of the governor of the states.